A little bit more formal way that cases can be resolved is called mediation. And mediation has become popular throughout the country and in Florida over the last, I would say, 20 years. And cases are mediated by a third party mediator, typically a lawyer who is trained in mediation, trained in how the process works, and trained in settling cases, will schedule a meeting. And both sides to the case, in our cases, we would be there, of course, with our client, and the insurance company representative would be there for an insurance company. If a lawsuit's been filed, the defendant, the person who caused the accident, could be there with their attorney and insurance representative. And so the mediator will conduct a meeting to try and settle the case with all parties present. And the mediator is a third party, as I mentioned, and is neutral and typically does not care how the case settles. The mediator doesn't care whether or not the plaintiff, the injured person, gets a lot of compensation or little compensation, and doesn't care how much the insurance company pays or how little they pay. The mediator is trained to get the case settled. And the way the mediator will do that is through a process of meeting all together, and then the parties separate and go into two different rooms. So the injured party, our client and lawyer, would be in one room, and the insurance company and the defense lawyer and the defendant would be in a separate room, and the mediator will go typically back and forth after that joint session in an effort to try and settle the case. And the process works because sometimes just having a third party get the message and take it to the other room, and mediators typically are very trained at helping one room consider what their risk factors are in settlement. For example, if the mediator is in the defendant's room with his or her insurance company and defense lawyer, the mediator might say, well, they make this point in the other room and they think you have a problem with this, and have you considered these risks to the position that you've taken in not settling the case? And the mediator will do the same thing in the plaintiff's separate room where we might be with our client. Have you considered this, or have you considered this? And typically through the process of the mediation, various offers will be made from one room to the other and then back to the other room, and the mediator will keep track, of course, where the offers are. And a lot of times parties can be a great deal apart. I mean, I've been to mediation where the parties were $10 million apart. And through the process of mediation, typically it just really works. And the mediator will go back and forth with offers, and the gaps can be closed. Now, sometimes, even with mediation, cases don't settle because it's not the mediator who makes a decision about what the case settle for. The parties have to come to an agreement. The mediator, as I mentioned, is trained to try and help those parties see risks in their own case to get to a number that both parties will agree to. And then the mediator will write up an agreement, and a lot of cases get settled that way. The mediation process really does work if both parties come with an open mind. And judges in our Northwest Florida area almost always require mediation before parties can get a trial date during litigation. And the reason is because mediation works. It helps judges reduce their caseload and helps with judicial economy. It gets cases settled. So rather than a judge having a lot of backed up trials on his or her calendar, a lot of cases get settled through mediation. So judges typically require mediation of both parties before the parties can get a trial date.